welcome to the Foul Play YouTube channel. Open mic number 242. Court of Appeals decision on KZ's brief, January 2025. Not good news, Doc and Susan. Not good at all.
No.
It's well, I haven't read it yet. I've just picked up, as I told you guys, just bits and pieces from what I earlier. So,
of course, it's not surprising to any of us, I think.
No. I'm not shocked. You know, hope for the best, prepare for the worst. Of course, KZ's, I guess, next only, well, she only has one direction at this point, and that's to appeal to the Supreme Court of Wisconsin, see if they'll take the case. If everyone remembers the last time she did that, they wouldn't take the case. It passed. So anyway, we've got the document. We're going to read it out here shortly. I would imagine, we'll discuss bits and pieces as we go. Looks like we have a pretty good crowd, but crowd of our usual suspects, as I say. Let's see, Sheila and Angie, Donna. Hey, there's Travis. There's a new name I've never seen before. Tackle Lover, Double D, Passive Bear, Under Your Scars, Pete Moss Alligator, Gloria. There's Crockett. How you doing, Crockett? Haven't seen you in a while. Corey, 3 Ravs. We appreciate all of you. You get to days like this. It's hard. It's tough, but don't lose your resolve. Don't give up. And, a lot of people do. You get to these situations. It's like, what the hell does it take to get these courts to see what we see? It's hard. Anyway, anything before we get going, Susan, Doc?
No, not really. Unfortunately, it's very much same old, same old. When we read the document, you'll see it's an incredible case of déjà vu. You've heard of all these arguments before. The same issues apply, and the court just rubber stamped everything. It truly is scaring. It took them so long to do, to basically rubber stamp the previous filing and response.
Yeah, Jamie's decision.
Yeah. You'll see that once we read it, you swear to God that you've read all this stuff out before, and guess what? We have. It's the same old arguments.
Yeah.
It's shocking to me that what Judge Angie wrote could be upheld. Shocking. Because to me, her decision and order was so bad. It was just so bad. But, they've linked arms from the very beginning in this case. There's been virtually, there's been damn near almost nothing as far as wiggle room at all. Everything has pretty much been denied from the beginning.
Yeah. Look, at the end of the day, none of us here should be surprised. Remember, it's lawyers protecting lawyers, and it's protecting the process. At the end of it, and of course we can discuss this afterwards, but it's no surprise. But I just want to assure everyone, and I'm sure everyone here on the panel, none of us are going to be swayed by this decision at all. It's not going to stop us doing our work. It's not going to stop us doing further research. It's not going to stop us trying to get the boys home by sticking to the case, sticking to the forensics. It's not going to deter us at all. In fact, it's going to drive us even harder. It's interesting that Susan pointed out that Bob Motta and his wife in the defense diaries did an analysis, and they even said the same thing. It's not going to deter them. They respect people's opinions, but they want to derive their own opinion, and it's not going to stop them from continuing their analysis. And I think that's a really great sign.
Good. Good. Well, that's
Okay.
Susan.
I just said agree. I agree.
Okay. Yeah. Okay. Well, I'm going to pop this document on, as always, in the comments section, the live chat. If you have any questions, please put a Q in. I'll try my best to get it highlighted, and we can go over them when we get done. I mean, this is not a very long document. It's 23 pages, and half that's, I'm sure we got beginning and end that's going to consume a little bit of that. So anyway, Susan, would you like to start us off?
Sure, Jeff.
Alrighty, you going to read from the screen? You have your own. You got your own copy, don't you?
I do have my own. Yeah.
The documents are not on the screen yet, Jack 61.
It is on my end. Oh wait, why did that not pop? Why did that not go on there?
Yep, I can't see it.
It went black screen on my end. What the hell's up with that? Try that again.
Look, it was trying to load.
Yeah, you tried to load again. Okay. Weird. Just a second. Stop it. And I'll close it and reopen it. Let's try that. That's really strange why it would do that. Okay, let's try that again.
There it is.
Hey,
Well, that was really weird. I've never had that one happen before. I've had some pretty weird shit happen on StreamYard, but that's a new one. Okay. Alrighty, state of Wisconsin, yada 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 versus Stephen Avery.
Appeal from an order of the Circuit Court for Manitowoc County. Angela Zakevich, judge, before Neubauer, Grogan, and Lazar, JJ. Per curiam opinions may not be cited in any court of this state as a precedent or authority, except for the limited purposes specified in Wisconsin Statute Rule 809-233. I find it odd that they've done both their opinions this way.
Yep.
Per curiam.
Yep.
Nobody's put a signature on the opinion.
no.
No.
Yeah. Per curiam. Stephen A. Avery appeals a circuit court order denying his Wisconsin Statute 97406 from 2021, and 2022. We want footnotes?
We can. If you
Oh,
guys
yeah,
want,
I think we should in this. Some of them.
Yeah, the footnotes are important.
Yeah. And all references to the Wisconsin statutes are to the 2021-22 version, unless otherwise.
No, okay.
Avery appeals the circuit court order denying his 97406 motion without a hearing on the basis that his motion was insufficiently pled. On appeal, Avery urges his motion was sufficiently pled to warrant an evidentiary hearing. We disagree and affirm the circuit court's order.
Are we going to read a point each?
Pardon?
Are we going to read a point?
We can just have you guys want.
I didn't understand. He cut out.
Oh, you know how it's got different points. Are we going to alternate the reading of the points?
Sure. Whatever you want to do.
Go ahead, Doc. Read number 2.
Yeah,
right, you know what? I'll read number 2, and you can read number 3. How about that?
Perfect.
All right. This is the third time Avery is before this court on appeal. We have previously summarized the facts of this case in State v. Avery, it says Avery, 2011, Wisconsin. So it's got the citation there, and State v. Avery got another citation.
Okay, point number 3. For context, on October the 31st, 2005, Avery arranged for Teresa Horbach, a 25-year-old professional photographer, to photograph a vehicle at Avery's Auto Salvage, Avery 1. At the time, Avery's Auto Salvage was located on a 40-acre piece of property owned by Avery's parents, Alan and Dolores. Avery, along with his brother Charles, lived on the property and worked at the salvage yard business. Another brother, Earl, worked at the salvage yard but did not live on the property. Avery's sister, Barb Yonder, lived in a trailer on the property with 3 of her sons, Bobby, Blaine, and Brennan Dassey.
As relevant, Bobby Dassey, then 19 years old, reported that on October 31, 2005, he was looking out a window from his family's trailer and saw Halbach arrive at approximately 2:30 p.m., take photographs of a vehicle, and walk toward Avery's trailer. Bobby then stepped away from the window. He never saw Halbach again. On November 3, Halbach's mother reported her missing. On November 5, volunteer searchers found Halbach's RAV4 in the Avery salvage yard. Quote, the vehicle was covered with branches, plywood, and the hood of another vehicle, end quote. After finding the RAV4, police searched the Avery property and over the course of the next 4 months, discovered and identified evidence including burned bone fragments in and around a burn pit with DNA matching Halbach's, both Avery's and Halbach's blood in the RAV4, the remnants of electronic devices and a camera, the same model in a burn barrel, Halbach's RAV4 key in Avery's bedroom with Avery's DNA on it, Avery's DNA on the hood latch of the RAV4, deposited, the state later claimed, by Avery's sweaty hands, and a bullet and bullet fragments in Avery's garage containing Halbach's DNA.
Okay, bullet fragments. One of them was completely irrelevant and useless, but they decided to pluralize that anyway. Okay. Avery 2, and it's got the number there, 2017. Number 5, the state charged Avery in part with first-degree intentional homicide as a party to a crime and a felon in possession of a firearm. The case proceeded to a 5-week jury trial during which Avery's defense was that law enforcement was biased against him and planted the evidence to implicate him, which the real killer exploited to also plant evidence on the property. The jury found Avery guilty.
Point number 6. In 2009, Avery moved for a new trial in part based on the circuit court's erroneous exclusion of Avery's third-party perpetrator evidence during trial. Avery wanted to implicate several alternative perpetrators in Halbach's murder, including, as relevant for the present appeal, Bobby.
That's still in your...
Oh, it's still mine?
Yeah.
Okay, because it's got the number 49. Yep. The circuit court denied the motion. Avery appealed and we affirmed. We determined the third-party liability evidence proffered by Avery identified a large group of individuals who he claimed were near the Avery property on the date of Halbach's murder, but who he acknowledged had no motive to harm her. This evidence failed to satisfy the legitimate tendency test under State versus Denny and was properly deemed inadmissible. Avery won.
Number 7. In 2017, Avery filed another 97406 motion raising new claims, Avery 2. The circuit court denied the motion, and Avery filed motions to vacate and for reconsideration, as well as 2 supplemental post-conviction motions. In one of his supplemental post-conviction motions, Avery included state withheld evidence, and this evidence would have established a Denny third-party perpetrator defense that Bobby had motive to kill Hava. The court rejected Avery's arguments without a hearing, and Avery appealed.
Looking for where that footnote is.
Oh, I'm sorry, I missed it.
Go ahead and read it.
Say, Denny created a bright line standard requiring that 3 factors be present for admissibility of evidence that an alleged third-party perpetrator committed the crime. State v. Griffin. Specifically, the defendant must demonstrate a legitimate tendency that the third party committed the crime. That is, that the third party had motive, opportunity, and a direct connection to the crime.
Interesting, they omitted the citation. Where were we at here?
Number 8, it's you.
Yeah, okay. Yeah, I got it. On appeal, Avery argued in part that the state improperly withheld evidence that Avery could have used at trial to establish Bobby had a motive to kill Halbach. Avery pointed to the final investigative report of Detective Mike Veely, saved on a CD, the Veely CD, which Avery claimed he received in 2018. Veely created this report through forensic examination of the hard drive of a computer from the Dassey family household. Veely's report identified items such as pornography, internet search terms, and chat messages from the Dassey family computer. Avery argued that the quote-unquote violent pornography contained on the Veely CD could have been used as Denny evidence because it revealed Bobby had a quote propensity for sexual violence, end quote, and therefore a motive to kill Halbach.
Point number 9. We disagreed. We determined the state did not improperly withhold evidence because it was undisputed that Avery's trial counsel had been given a copy of the Dassey family computer hard drive, and the Veely CD did not contain any additional information other than what was provided to counsel.
That is such crap right there.
It is complete bullshit.
Yeah.
And we proved this. It was evidence because Fassbender held it and didn't turn it in until June 1st, 2007 to Wiegert. It's in the ledgers. It's evidence. It's tagged
It's
as
evidence. It's a report from, looking
from another cop.
Right. Travis says they are compiling a history of hotly contested facts and present them almost as uncontroverted facts when they were highly controverted, and the facts resulted by default.
Sounds about right, Travis.
Yep. Number 10. We also determined Avery failed to establish trial counsel was ineffective for failing to analyze the Dassey family computer hard drive. We first noted that Avery's assertions that only Bobby could have downloaded the images from a communal computer used by several people were factually unsupported. We then explained that even if the VDC to establish the motive problem of the Denny test, quote, Avery failed to meet the direct connection requirement in his original Denny motion and has not presented additional evidence on this point, end quote. Therefore, Avery could not demonstrate a reasonable probability of a different outcome at trial.
Doc?
It's you, Jack.
Oh, is it?
Yep.
Did I go
Number
out of
11.
turn?
No, it's Jack. And
Okay.
I'm asking
Okay.
Jack.
Okay.
Number 11. In 2022, Avery filed the Wisconsin Statute 97406 motion underlining the present appeal. He first argued testimony from his newly discovered witness, Thomas Sawinski, quote, provides the missing direct connection between Bobby and Miss Halbach's murder, making him, Bobby, a Denny suspect, end quote. In support, Avery attached Sawinski's affidavit to his motion.
Point number 12. Sawinski averred that before sunrise on Saturday, November the 5th, 2005, he was delivering papers to Avery's Auto Salvage. While there, Sawinski saw Bobby and an identified older male in his 50s or 60s with a long grey beard, quote, pushing a dark blue RAV4 down Avery Road on the right side towards the junkyard, end quote. Bobby did not look happy to see Sawinski and attempted to step in front of Sawinski's vehicle to prevent him from leaving. Sawinski swerved around Bobby and called out, quote, paper boy, gotta go, end quote. Sawinski believed that Bobby and the older individual, quote, were doing something creepy, end quote. Sawinski learned Halbach's RAV4 was found in the salvage yard later that day. Sawinski averred he contacted police and an officer told him, quote, we already know who did it, end quote, as well as told him they would contact him, but never did. Footnote number 3.
Yep.
In his initial affidavit dated April 10, 2021, Sawinski averred he gave this information to Avery's trial attorneys. In August 2022, Sawinski amended his affidavit in part to reflect that he did not give this information to Avery's trial attorneys, but instead emailed the Innocence Project in New York. He then attached the body of an email that he sent more than 8 years earlier in January 2016. The January 2016 email is different from Sawinski's current affidavit in several respects. In the email, Sawinski stated, quote, after seeing the documentary on Netflix, he decided that someone other than Manitowoc County officials need to hear this, end quote. He wrote that, quote, somewhere between October 31st and November the 5th, 2005, not sure which day, end quote, he went to Avery's property to deliver a paper. He said he ran into two people pushing, quote, a dark color small SUV down the road. They were pushing it in the direction towards the house from the highway, end quote. Sawinski wrote, quote, it was dark and I delivered the papers as soon as possible each day so I could get home in time to get my son ready for school and drop him off, end quote. He said he, quote, didn't see who the man was on the passenger side, but the young man, maybe 18 or so, that tried to stop me was not Brendan Dassey. His build was thin and fit and about 5 feet, 9 inches tall, end quote. Sawinski wrote that, quote, after seeing the footage on TV of the RAV4 being found on the property, it clicked that it was probably the SUV I had seen that night, end quote. He said, quote, called police and notified them. They didn't seem interested at all and said, thanks for the info. Never asked me to fill out a report or even ask for my name or phone number. Is this me continued?
No. Let's chat.
No.
Okay.
13. In his motion, Avery asserted, this new evidence allows for a reconsideration of the real motive of this crime as being a sexual homicide, which was the culmination of an obsession by Bobby with viewing thousands of images of violent, deviant pornography. On October 31, 2005, the obsessive fantasies of Bobby became a horrible reality when Teresa Halbach was brutally assaulted and murdered by 2 rifle shots to her skull. Her body was mutilated, as were many of the female subjects in the Dassey computer images. Bobby was in possession of the Halbach vehicle, which contained the crucial evidence of this terrible crime. Ms. Halbach's blood, key, electronic devices, and license plate, which was concealed in another salvage car, and Mr. Avery's carefully deposited blood on the seats and the dash, and DNA on the hood latch. By being in possession of the vehicle, Bobby was able to control the direction of the investigation. He planted the vehicle on the Avery property after he deposited Mr. Avery's blood and DNA in it. He had Miss Halbach's key and electronic devices, which ended up in Mr. Avery's bedroom and burn barrel. Bobby did all of this to exculpate himself and to frame his uncle, Mr. Avery. Avery also argued the state committed Brady violations for failing to disclose the Sawinski evidence and for failing to disclose evidence from witness Kevin Ramlow, who averred he observed Halbach's vehicle on the street days after her disappearance. Finally, Avery sought a new trial in the interest of justice.
Number 14. After briefing on Avery's post-conviction motion concluded, but before the circuit court decided the motion, Avery filed an affidavit from another purportedly new witness, Thomas Paresh. Paresh averred he saw Bobby driving a RAV sometime before 2 a.m. on the night of Friday, November 4, 2005, to the morning of Saturday, November 5th, 2005.
Point number 15. The circuit court denied Avery's motion without an evidentiary hearing on the basis that the motion was insufficiently pled. Avery appeals. Additional facts will be provided below.
You know, before we start the discussion, I want to refer back up here to what they've done, talking about Sawinski from 2016, basically. I'm not sure why they would do that instead of referring to his affidavit, which is the current affidavit, and his girlfriend about the call he made.
Well, you know why they're doing it, Jack 61.
Well, I mean, it diverts the discussion. I mean, to me, away from his more current affidavit and his girlfriend, plus the phone call.
Yeah, the whole idea is to discredit him.
Yeah.
So
but the whole idea is that this should be sent to an evidentiary hearing to be fleshed out.
Correct.
You know, the inconsistencies and all of that. That's, I mean, they're deciding, you know, that
Correct.
it's not
relevant.
Not relevant. But that's not the way the law is.
No, but it is according to these guys, right? So the argument is that because of Sawinski's inconsistent statements, they're discrediting him before actually placing him on the stand and questioning him. So if you notice, and you made a really good point, Susan, and same with Jack 61, if the constant argument is insufficiently pled. Yeah. So the whole idea is to put a stopgap. We don't want to hear you. We don't want to hear your witnesses. We don't even want to put them on the stand. We're going to successfully legally block this and not give you the chance to speak. So therefore, what they're looking at is Sawinski, Baresh. They're looking at their statements, everything they've said in social media, and they're comparing this statement with that statement. They're going, oh, these statements are inconsistent. Therefore, they're putting the argument that, hey, we don't need to listen to your witnesses. We don't believe them. But what they're cleverly neglecting is that whatever happened after the call got transferred to Seglob is irrelevant. It's what Sawinski told Seglob on November the 6th. Would you guys agree?
Yeah. Plus the fact
Yeah.
that, as you correctly pointed out months ago, well, maybe even more than months, they never interviewed Sawinski. And of all the people that were on the property every day, they never talked to him.
Correct.
And I
Correct.
think by saying that they insufficiently pled it, they're basically saying, we don't like the way that you've laid this out. And it's almost like a procedural bar to me. They're being very detailed and specific in the way Kat has explained everything. And they don't feel like it's sufficient for their.
Well, they're being very evasive too.
Yeah.
Me. And what Travis said, which is another point I'm thinking this entire time, this is supposed to be just to be whether the trial court was correct in denying an evidentiary hearing. And look at what we're getting. Excuses.
It's not as that. It's not as though they're asking for a new trial. I mean,
True.
They don't want to hear the state don't want to hear them at all.
no.
They do not want to hear them at all. And you can see, and plus now we're going to get into the background and the evidence. Whatever was agreed to in court is the truth. Nothing else is going to be entered into. Because you remember the statement that they read out, the 2 bullet fragments, the DNA present on the bullet. You saw in our podcast that we did Reading with the Crew, how we completely destroyed it. From a legal standpoint, none of that matters.
No.
Because none of it has been entered into in front of a judge or a jury.
Right.
So therefore, their parameters are like this, Jack 61 and Susan, and everyone in chat. Their parameters are like this. They do not want to enter anything else. This is the truth, and that's what we're going with.
Well, they're making the decision that an evidentiary hearing would.
Correct. Yep. Correct.
They're saying it's our opinion that you don't have enough there, or it's not legitimate, or it's not. They're making that decision insufficiently pled.
Yeah, but nobody wants to sign their name to it. Interesting.
Yeah.
All right. Discussion number 16. The issue in this case is whether Avery's Wisconsin Statute 97406 motion was sufficient on its face to entitle him to an evidentiary hearing. As a threshold matter, we observe that on appeal, Avery makes no argument regarding the sufficiency of his pleaded Brady or interest of justice claims. See A.O. Smith, they've got a citation here. Quote, an issue raised in the trial court but not raised on appeal is deemed abandoned, end quote. We will therefore not consider them further. What does that mean? An issue raised in the trial court but not raised on appeal is deemed abandoned. Okay. Sorry about that. Go ahead, Doc.
He made no argument that of its sufficiency. That makes no sense to me.
So they abandoned it. won't consider it.
Yeah. Yeah.
Point number 17.
Yep,
As to
that's mine,
Oh,
isn't it?
are we changing the order?
Don't
I
I
don't
follow
mind.
Jack?
No,
thought
I
was
do.
following. Oh,
I
go
do.
ahead. Okay, I'm confused.
Yeah, we could blame Jack. We changed the order. Okay,
Yeah, it's
so
my fault.
yeah, no hassles. Point number 17. As to Avery's newly discovered evidence claims and whether his motion was sufficient to entitle him to an evidentiary hearing, sufficiency of a post-conviction motion is a question of law, which we review de novo. See State versus Bailette. Quote, if the motion raises sufficient facts that, if true, show that the defendant is entitled to relief, the circuit court must hold an evidentiary hearing, end quote. If the motion is conclusory, or if the record conclusively demonstrates that the movant is not entitled to relief, the circuit court may deny the motion without a hearing. It's you, Susan.
Yeah.
I think you're muted.
I thought I unmuted. I'm sorry. Number 18. In his 97406 motion, Avery alleged he had newly discovered evidence from a new witness that, quote, provides the direct connection between Bobby and the Halbach murder, implanting evidence to frame Mr. Avery. Capitalization and emphasis omitted. When seeking a new trial based on the allegation of newly discovered evidence, quote, a defendant must establish by clear and convincing evidence that 1, the evidence was discovered after conviction, it was. Number 2, the defendant was not negligent in seeking the evidence, he wasn't. Number 3, the evidence is material to an issue in the case, absolutely, in my opinion. And 4, evidence is not merely cumulative. State v. Edmonds. Quote, once those 4 criteria have been established, the court looks to whether a reasonable probability exists that a different result would be reached in a new trial. They make it next to impossible, basically.
Well, I mean, you know, if we think about 2007, if there was during the trial and Sawinski was presented as a witness, would it have
I
mattered?
think it definitely have changed the outcome.
I do too, because they would have been forced to put Singlove on the stand. These recordings would have come out much sooner,
Right?
potentially. Yeah, absolutely.
And it introduces a third party defense.
All right, is it my turn?
Yes.
Okay. 19. The circuit court determined that the Sawinski evidence satisfied the first 2 prongs of the newly discovered evidence test. Evidence was discovered after Avery's conviction, and Avery was not negligent in seeking the evidence. However, the circuit court stopped its newly discovered evidence analysis after it determined Avery failed to demonstrate that the evidence was material to his third-party perpetrator defense. Got a footnote here. Avery's brief to this court incorrectly states that the circuit court found that, quote, Avery satisfied all the elements required to admit his newly discovered evidence, but for the materiality requirement, end quote, because the circuit court found that Avery's motion failed to meet the materiality requirement, it did not reach the 4th prong of the test or determine whether a reasonable probability existed that a different result would have been reached at trial. Oh, I think you're full of shit. Anyway, going back up, third-party perpetrator evidence is only material if it would be admissible under Denny. It's got a citation.
Point number 20. On appeal, Avery argues the circuit court erred by only analysing the materiality of his newly discovered evidence within the confines of a third-party perpetrated defence. He argues, quote, In determining that Mr. Avery's new evidence could only be material to the issue of a potential third-party suspect, the court completely ignored its inherent materiality to other material issues in Mr. Avery's case, end quote.
Number 21. To the extent Avery's post-conviction motion could be interpreted that the Sawinski evidence was independently material of any third-party perpetrator, we conclude his motion is insufficiently pled. Avery only analyzed the Sawinski evidence within the context of a third-party perpetrator defense. As one example, the fourth prong of the newly discovered evidence test requires the defendant to establish the newly discovered evidence is not cumulative. See Edmonds. In regard to that prong, Avery offered a single sentence. Quote, the Sawinski evidence provides for the missing direct connection to Bobby as a third-party suspect for Ms. Halbach's murder and therefore not cumulative, end quote. Avery did not offer any analysis that explained why his newly discovered evidence was not cumulative outside of his third-party perpetrator defense.
Number 22. Yeah. As another example in Avery's analysis of whether a reasonable probability exists that a different result would be reached at trial, Avery argued, if Bobby is established as a viable third-party Denny suspect, for the forensic evidence in this case is completely undermined. The newly discovered evidence that Bobby was in possession of Ms. Halbach's vehicle means that he had opportunity and access to plant evidence in the vehicle from the vehicle. Because Bobby had been directly linked to the murder of Ms. Halbach, there is a reasonable inference that he planted the bones in Mr. Avery's burn pit. This new evidence creates a reasonable probability that had the jury heard the new evidence, it would have had a reasonable doubt as to the defendant's guilt. Therefore, Mr. Avery should be granted a new trial. See Ballbreaker.
Point number 23. Again, Avery did not offer any analysis that explained why his newly discovered evidence created a reasonable probability of a different outcome on retrial that was independent of his assertions that Bobby murdered Halbach and framed him for it. The circuit court properly recognized Avery's newly discovered evidence was not independent from Avery's attempt to meet Denny and addressed whether the evidence was material within the confines of his third-party perpetrator argument.
Number 24. Avery next argues the circuit court erred by denying his post-conviction motion because he asserts his newly discovered evidence satisfied Denny's legitimate tendency requirement and established Bobby murdered Halbach and framed him for it. It contends the circuit court erroneously imposed a substantial certainty requirement and misapplied Denny in its evaluation of whether Avery's proffered evidence satisfied the Denny elements of motive, opportunity, and direct connection.
25. As stated previously, third-party perpetrator evidence is only material if it would be admissible under Denny. Another citation. Under Denny, the defendant must show, quote-unquote, a legitimate tendency that the third party committed the crime, which is demonstrated by establishing the third party had motive, opportunity, and a direct connection to the crime. Did we miss this footnote here? We must have. In Ballbreaker, we affirmed that the circuit court's grant of a new trial on the basis that the newly discovered evidence satisfied the requirements of Denny and created a reasonable probability of a different outcome at retrial. Another citation. Okay, moving on. A defendant's offer of proof on these three prongs is insufficient if it merely establishes a bare possibility that the third party could have been the perpetrator?
Point number 26. We will start with motive. Quote, motive refers to a person's reason for doing something, end quote. In evaluating the motive prong, we ask whether the, quote, alleged third-party perpetrator had a plausible reason to commit the crime, end quote.
I'd just like to point out once again that the state does not have to prove Stephen's motive. Just pisses me off that they have to. The other way
But-
around.
But the defendant does.
Yeah. Number 27. In his post-conviction motion, Avery asserted Bobby had motive to kill Habak because Bobby searched for violent images on the family computer, which established Bobby had an obsession with violence and was more likely to commit murder. In support of his theory, Avery first alleged in his motion that there were 1,625 violent pornographic images recovered on the Beeley CD. He stated the recovered pornographic images, quote, depicted violent images of the torture and mutilation of young females, end quote.
28. These statements are not supported by the record citations offered by Avery in his post-conviction motion. His computer expert's affidavit, which he cites in support of his first proposition, does not establish there were 1,625 violent pornographic images on the Dassey family computer. The report simply states there were 1,625 additional images categorized as recovered pornography. Nothing in this affidavit established that each recovered pornographic image was violent. Really? As for Avery's next assertion that the recovered images depicted violent images of the torture and mutilation of young females, Avery cites pages from his computer expert's affidavit in support of that proposition. However, again, the page citations offered by Avery do not establish the pornographic images were violent images of torture and mutilation. At best, the citation provides that the Beeley CD contained 2,632 searches for terms. And it gives the various terms. I don't need to read all those out. These search terms in no way establish that the pornographic images were violent images of torture and mutilation. I'm going to stop here just 1 second briefly, and maybe you guys can remind me. Are they reaching back to previously denied 97406 motions? Is that what they're doing here? I think they are. I thought those were denied. Why are they quoting something that from, or did I misread that or misunderstand it? You guys understand?
I'm not sure, Jack.
Yeah.
Travis, can you clarify here? Are they reaching back to 2017? Some of the, or 2019, some of the previous, or one of the previous 97406 motions, and pulling that into this? And I'm not sure why that they would even allow that. I don't know. Maybe I'm speaking out of step here. My memory's worse than I think it is. Anyway, moving on.
Point number 29. That being said, we recognize the record does at least suggest there were some pornographic as well as gory images found on the Dassey family computer. We will therefore assume, for purposes of Avery's post-conviction motion, that there was some quantity of what could be classified as violent pornographic images found on the communal computer. Well, at least they admitted to that. That's a start.
Now it's the communal computer.
Yes.
Yeah. And Travis says they're doing that repeatedly, Jack.
Gotcha. Thank you, Travis.
Number 30. However, even with that assumption, the fundamental problem with Avery's motion is that he fails to tie these violent pornographic images to Bobby. In his post-conviction motion, he attempted to tie these images to Bobby by arguing that because Bobby routinely worked night shifts and was at home during the day from 7 a.m. to 3:30 p.m., while other members of the family were routinely at school or at work, it followed that Bobby conducted the searches for these images. This is conclusory and speculative. Footnote number 6. In support of his assertions that, quote, there is sufficient evidence that it was only Bobby who had access to the DASI computer during the day on weekdays between approximately 7 a.m. and 3:30, in part, a record citation to a state's brief. In the record citation offered by Avery, the state argued. That's continued down below. The computer was accessible to numerous people. Brendan Dassey, Blaine Dassey, Scott Tuddock, Brian Dassey, Bobby Dassey, Barb Yonda, and Tom Yonda all either lived in the house or had visited the house up until October 15 of 2005, when Tom Yonda moved out. The 4 Dassey brothers and Barb Yonda lived in the residence from October 31, 2005 to March 1, 2006, when Brendan Dassey was arrested. Stephen Avery was a regular visitor to the Dassey house, giving him access as well. This passage demonstrates the need for non-conclusory evidence establishing Bobby was the individual who searched for the specific images of alleged violent pornography.
I wonder where this information come from. I bet I know.
Yeah.
Don't go there, Jack 61.
Yeah.
Hey, Doc, I'm sorry. I'm just following where my car's driving. My bad. Where we at? 31?
Yep.
That's you, right?
No, that's you, Jack 61.
Crap. I got confused again. Moreover, to establish Bobby's purported obsession with violence, Avery alleged 128 searches for the most violent porn images primarily occurred on weekdays when only Bobby was in the Dassey residence. In support, Avery cited his computer expert's second supplemental affidavit. However, of the searches listed, only 28 of them occurred between 7 a.m. and 3:45 p.m. on a weekday. Then, of those 28 searches, only 3 of them occurred before the Hallbox murder. Even accepting Avery's unsupported speculation that only Bobby had access to the Dassey computer during that time frame and conducted the searches, and assuming that the 3 searches were in fact for violent pornography, Avery failed to explain in his post-conviction motion how someone only possibly having searched for pornography 3 times established his theory of motive, that Bobby had an obsession with violence and therefore was more likely to commit murder. His allegation is conclusory and speculative. Well, that's a really interesting set of information there. And I have to ask before we move forward, I apologize for interrupting you, Doc.
No.
I'm just trying to think here. I've lost my train of thought here. I had a really good point to make, though. The 128 searches for the most violent. Oh, I know what my point is. Thinking back to the last time the Court of Appeals had this case, they had this freaking, I'll correct my wording here, that freaking Billy CD, and they didn't already know this information, and now they've got all this new information. I didn't think they were a fact-finding court. Huh. Right? They're not a fact-finding court. That's what I understand. I'm not a lawyer, but it's not their job to be a fact-finding court. So Just wondering where these facts came from. And I question that, knowing that Travis is in listening in, if he cares to comment on my thought process here, where did it come from? Number one, and number two, why would they include it in their decision? That's all I got to say about that. I'm sorry for interrupting, Doug. Thoughts if you
No,
guys want to talk about that?
Yep, I'm not at all. I mean, for me, now remember, I'm not a lawyer or an attorney. I don't have a legal background, so please forgive me for my ignorance. It's rather remarkable. This is a court of law, and their argument is they're trying to set a cutoff point of what they consider to be violent pornography.
Yeah.
And not only that, they've now admitted that there was violent pornography. Their argument is, hey, if Bobby was the only person who accessed the computer between a certain time, and if 3 of those searches were for violent pornography, their argument is, well, is that a cutoff point for his obsession? I'm not, now remember, I have no evidence that Bobby searched for anything. I'm just echoing the argument made by the court. So they're trying to come up with a cutoff point. Well, what do you consider to be an obsession with searching for violent pornography? Only 3? Really? Don't worry about it. This is a court of law. And the argument is that someone or several people in the Dassey household were downloading, viewing violent pornographic images involving torture, death, mutilation. There was also images of underage sex involving children. Has anyone been convicted, charged, slapped on the wrist for the contents of the communal Dassey computer? Anyone?
Yeah.
Nope.
So
No.
we've got something very interesting here. It's the way the state are slicing the pie. You get it?
Mhm.
So they know. And this is what infuriates me, Jack 61 and Susan. They had the Veely CD a long time ago. They knew the contents. They knew the contents of that computer, the Dassey computer, was explosive, because a competent attorney like Strangle Buting would have used it against Bobby on the stand in 2007. Agree?
Yep.
Agree?
Yep.
So therefore, because that opportunity was never given, the attorneys for Stephen never had the opportunity to test the waters and test the judge and the jury. The courts now are arguing, don't worry about it. It's trivial. Yes, there was pornographic images. However, our argument is, well, A, you can't prove that it was exclusively Bobby. That's true. But you can't exclude him either. You get it? You can't exclude him either.
You can't. But
No.
if you can include him on some of them.
Yes, which you can.
Yeah.
But their argument is Stephen had to prove by video camera that he saw Bobby downloading this material at this time, and just Bobby.
Yeah.
That's the argument of the court. Now, Fassbender, he was on a task force, Internet Crimes Against Children. He sat on the Veely CD for how long, Jack 61?
Basically 7 months. Well,
And
actually, it was longer than. I mean, it was listed. It was actually longer than that.
Yep.
It was. He reported it. He got it in May. He reported it in December in his report. He turned it over to Wiegert in June 1st, 2007. So he held it
after the trial.
After the trial, both trials were complete, and sentencing hadn't happened yet. But
so my question is this: if the contents of the DASI computer were trivial and nothing of evidentiary value, why didn't they disclose the full report to Strang and Buting and then blame Strang and Buting for getting information that said Brendan Dassey's computer and saying, see, it's your fault, guys. You had to decode the information. Oh, we've done it, but we're not going to give you the report. So we have these weird arguments where there's damning information on the Dassey computer. And the computer was videotaped in Bobby's room. Now, I could imagine Bobby won't be too happy. His younger brother saying, hey, mate, we're going to use the computer. We're going to play games or whatever. I'm sure Bobby would take precedence if that computer is in his room. It's interesting that the arguments are being put forward by the court, trivializing what's on the computer.
Yes.
The fact that it mimics so much the state's what they believe happened to Teresa.
Correct. And that's why they put a search warrant for Stephen's computer. Yep.
Yeah.
And they listed in the search warrant exactly what they were expected to be found. Images of torture, mutilation, murder, you name it. Except the state failed to find that on Stephen's, but they found it on his nephew's computer.
Yeah.
So notice what they've done. They've diluted the effect. How did they do that? They included all the possible people that visited the younger residents, including Stephen.
I'm surprised they didn't list. I'm surprised they didn't list the boy's friends in there too, Doc.
Yep, correct. So notice what they're doing. They know it's damaging, but legally, how can we diffuse it? How can we disarm it? Okay. Oh, Stephen could have come over. So despite Stephen having his own computer, no. He potentially could have gone to the younger residents to download violent pornographic images, even though he had his fiance. It's sort of like, what the hell? It's interesting, their strategy.
Well, again, I hate to be, a repeating Randy or whatever you want to call it, and continue to bitch about this. But if that CD, remember there was a period of time many years ago, I don't know if you guys remember this or not, Kratz called this Beeley CD work product, and that the defense was not allowed to have it. You guys are not allowed. But the true fact is, and he had to know this, that CD was entered into the ledgers, in the COA ledgers, on June 1st, 2007. If it was evidence on that date, it was evidence on May 11th, 2006. There's just
that is not work product. I'm sorry.
It's not. If it's entered as evidence, work product does not. It doesn't leave the prosecutor. It's not given to a state cop or a county cop. It's work product that stays in the prosecutor's control. So so the Court of Appeals. I just don't get it. And look, we can even back up and look at this at a different angle. I like to try to do that to be fair. And I'm not trying to play a devil's advocate. I'm just trying to be fair and reasonable. If we back up and we take that CD back to trial, let's just say that that it did come in, that it was turned over to Buting and Strang. What do you guys think could have potentially happened? I don't know.
Well, Strang and Buting even said it, Jack 61. Sorry to interrupt. They wrote an affidavit, and we did a podcast on it. They said that we would have adjusted our questioning of Bobby Dassey to directly question him about the contents on the computer, because we would have treated him as a third-party Denny, but we're not permitted to. Remember the deals that they came up with before? The only third-party suspect they could talk about was Brendan, right? So they were playing hands-off. The state were playing hands-off, and it worked perfectly. They're now doing it at the other end, right? through the appeals of Kathleen Zellner. They're now playing hands off again by saying, don't worry, it's trivial.
Well, even
know,
remember the in-camera Denny hearing in January of 2007. They were continuing to still hide this CD, this Bealey CD. Bobby's name was on that list. Now, look, I'm not saying Bobby did a damn thing. Please don't want anyone out there think that that's what I'm saying. I'm not. I'm just saying his name was in that pool. And Willis even said, right, you've got everything but motive. Now, would that CD have proven motive? We don't know, because if Beating and String had got that CD and turned it over to the investigators or whatever, we don't know where that road would have led or what else could have been found out about anyone, let alone Bobby.
Because it wasn't tested. It wasn't tested.
That's right.
It wasn't put in front of a judge and a jury in situ at that time.
That's
and
right.
Now,
looking at it logically, you would think that it would have changed the trial tremendously.
Oh, I think so. I think it would have, because now you've opened up a whole new avenue of things to consider and to flesh out.
Yep. But if you notice, and I don't want to be disrespectful, if you notice what the court are doing, the court are speaking on behalf of Bobby. You get it?
They are, and that's why I pointed out these included facts above, Doc.
Yep. The court is Bobby Dassey's voice, and they're defending Bobby. Yep. They're not allowing Bobby to go on a stand and defend himself, to say, no, I was sleeping, or I never would have downloaded this. They are acting on behalf of Bobby Dassey. Because why? Because Bobby Dassey is Kathleen Zellner's third-party Denny, rightly or wrongly. So now they're defending him and are his voice. And they're trying to trivialize the contents on the computer as being, don't worry about it. Yeah, okay, we admit there was some nasty stuff there, but you can't specifically prove that it's him. But on the same token, you can't disprove it wasn't him. So he's in the pool. He's in the pool of potential individuals that were viewing and downloading this material. Now, I understand boys are boys, but this stuff was off the charts in shocking and also underage sex involving young children. Man, in Australia, you have just one of those images on your computer, you're done. So now the court is arguing 3 searches. Don't worry about it.
Well, 3 for Bobby, they're saying, but there was a lot more images on there. And again, nothing investigatively was done, and Fassbender knew about it. So if Fassbender knew, that means the superiors knew too. He had to, I'm sure he told them in a conversation or some kind of report that's private, but I shake my head at this whole Bealey CD thing.
Correct.
Sorry, Susan. I didn't mean to. She have something to add?
No, that's fine.
Oh, okay. I thought I saw your mic.
I think it's my turn.
Yep.
Number 32. Yep. Awesome. 32. The circuit court found that Avery's motion was insufficiently pled because Avery provided nothing that would establish Bobby was the one who conducted the searches for the pornography found on the Dassey family computer, or that he was even at home at the time the searches were conducted. The circuit court also observed the search terms used were generic and broad and did not closely resemble anything about this case. The circuit court noted that there were only a small amount of searches that occurred before Hallbuck's murder. Point number 7. Shall we read out number 7? Okay.
Yeah, the footnote, yeah.
Okay. In his brief to this court, Avery argues that the circuit court erred by determining only a small number of searches occurred before Hallbuck's murder. He asserts that, quote, on September 18, 2005, there were 75 searches of violent, child, or underage pornography performed on the Dassey computer, obviously prior to Miss Horbach's murder, end quote. In support, he does not cite to a fact pled in his post-conviction motion. Instead, he cites to one of the 84 exhibits he attached to his post-conviction motion, specifically a supplemental affidavit from his police procedure expert. Okay.
It continues.
That's number 8.
No,
No.
number 8's below that. No, you got another paragraph for that.
Okay. It is unclear the foundation for this expert statement. After all, as Avery pled in his post-conviction motion, his computer expert identified, quote, 128 searches for the most violent porn images, end quote. And the expert's affidavit reveals that none of these searches occurred on September 18, 2005. More importantly, September 18, 2005 was a Sunday, which is when multiple individuals had access to the communal computer. Assuming searches of some kind did occur on Sunday, September 18, 2005, Avery does not explain how these searches can be tied to Bobby. We will not consider this argument further.
Wow.
Yep. End of story. Okay, so on point number 7, just scroll up a little bit, check this one. That's it. Beautiful. The court also observed the 2 experts' opinions Avery submitted were based on the unsupported assumption that Bobby conducted the searches and were produced without any forensic or psychological examination of Bobby himself. We agree with the circuit court that Avery's post-conviction motion does not sufficiently allege non-conclusory facts that Bobby had motive to kill Horbach. Do you want me to read point number 8? Number 8? Yeah, beautiful. In his brief to this court, Avery contends that if Bobby's motive was not sexual, quote, the motive for her murder may have been a theft by Bobby of her vehicle and the items within it, end quote. This was not pled in Avery's post-conviction motion. It is also conclusory and speculative. We do not consider this argument further.
Okay.
I don't either. Number 33. We could stop the analysis here. After all, by failing to sufficiently allege non-conclusory facts demonstrating Bobby had motive to kill Horbach, Avery has not established that his newly discovered Sawinski evidence is material for his third-party perpetrator defense. See, Denny test is a 3-pronged test. It never becomes a 1- or 2-pronged test. Volbrecht, Denny requires that all 3, motive, opportunity, and direct connection, be shown before evidence of a third-party perpetrator is admitted at trial. However, in the interest of completeness, we will continue the analysis.
Okay. 34. We next turn to the second prong of the quote-unquote legitimate tendency test, opportunity. Opportunity, quote, ask whether the alleged third-party perpetrator could have committed the crime in question, end quote. Wilson. The defense theory of a third party's involvement will guide the relevance analysis of opportunity evidence in a Denny case. Sometimes opportunity can be established by simply showing that the third party was at the crime scene. However, when the theory of how the third party committed the crime requires the person to have carried out a series of complicated and difficult tasks, it is not enough to show that the third party's mere presence at the scene and an unaccounted for period of time. Wow,
That
there's a
is
lot of
such
prosecutors.
bullshit.
There's a lot of prosecutors that sure have convicted a lot of people. What's it called? The
Unconjugated
yeah,
co-conspirator.
yep. Is there,
35.
did
Well,
we miss a footnote?
if you just,
Oh,
if
the
you
foot.
just,
Yeah, you got the footnote. I'm sorry. Go ahead, Doc.
I was going to say, it's if you just scroll down a little bit, I just want to read what was said. Can you just scroll down a bit, Jack 61? It basically said how the third party committed the crime requires that person to have carried out a series of complicated and difficult tasks. Now, if it's complicated and difficult task for a third party Denny, how come it's not a complicated and difficult task for Stephen and Brendan Dassey?
That's right.
In the unaccounted for period of time.
It's a double
'Cause
standard
remember-
again.
Yep. Remember, Stephen and Brendan had a very limited time in which to carry out the murder and the cover up and the cleanup.
Yep.
So it's impossible for a third party Denny, but it's entirely possible for Stephen and Brendan.
Yep.
I love it.
Amazing.
Okay. Point number 35. You just might have to scroll up a little bit, Jack 61. Thank you. Point number 35. In his present motion, Avery alleged that Bobby killed Hallbach on October 31st, 2005, and then framed him for it. Therefore, to
Footnote,
establish... Oh, you want me to read the footnote now? Okay.
Yeah.
Footnote number 9. In his brief to this court, Avery complains, quote, the circuit court erroneously found that Miss Hallbach was murdered on October the 31st, but there is no proof of when Miss Hallbach was murdered up until her remains were found on November the 7th. However, in his post-conviction motion, Avery specifically alleged, quote, on October 31st, 2005, the obsessive fantasies of Bobby became a horrible reality when Teresa Hallbach was brutally assaulted and murdered by 2 rifle shots to her skull. End quote.
Well,
emphasis added.
Got a couple of points on this footnote. Number 1, I thought it was November 8th when the remains were found.
Yes.
Yeah.
Number 2, although it was inferred all the way through trial, the state, no one on the prosecution, definitively said Item FK and Item FL were the 2 bullets that killed Teresa, basically.
Correct. And I'll just continue. Therefore, to establish opportunity in this case, Avery, quote, must provide some evidence that Bobby had the realistic ability to engineer such a scenario.
Wow. Okay. Number 36.
Number 30.
That's Susan.
I'm sorry. No, that's Susan. My bad.
Okay. Number 36. Avery contended that Sawinski's affidavit established Bobby was in possession of Hallbach's vehicle and had the, quote, opportunity access to the items that he stated. Bobby was in possession of the Hallbach vehicle, which contained the crucial evidence of this terrible crime. Ms. Hallbach's blood, key, electronic devices, and license plate, which was concealed in another salvage car, and Mr. Avery's carefully deposited blood on the seats and dash, and DNA on the hood latch. By being in possession of the vehicle, Bobby was able to control the direction of the investigation. He planted the vehicle on the Avery property after he deposited Mr. Avery's blood and DNA in it. He had Ms. Hallbach's key and electronic devices, which ended up in Mr. Avery's bedroom and burn barrel.
Wow. 37. The Sawinski affidavit, however, only stated that Sawinski saw Bobby and another individual pushing a blue-colored RAV4 on November 5, 2005. Nothing in the Sawinski affidavit linked Bobby to Hallbox RAV4, its key, or her electronics. Holy shit. Avery failed to offer anything other than speculation that Bobby possessed Hallbox RAV4, its key, or her electronics.
It was some other.
Can I make a comment here?
Please.
Right. Now, let's make the assumption that what Sawinski saw was true, and leave Bobby and this other gentleman out. If you distill it right down, if what Sawinski saw occurred, that he saw two males pushing a dark blue RAV4 up Avery Road, that whole incident would have taken a minute, not even a minute, right? And of course, someone like Sawinski encountering these two individuals, he wasn't expecting that. So the court is now trying to say that because Sawinski failed to ask the guys pushing the RAV, by the way, do you have a set of keys? Do you have a mobile phone? Yeah. Do you have a mobile phone in there? Do you have a purse or some electronics? That the state are now arguing because Sawinski never observed the two people pushing the RAV4 in possession of the key, the electronics, the camera. Well, how are you going to link Bobby Dassey potentially to those items? It's got to be one of the most bizarre arguments I've ever seen.
But they're also saying that, how do you prove it was Hallbox RAV4? It could have been anybody's RAV4.
As people like pushing RAV4s onto a property
at my
in the morning, at 2 a.m. in the morning, or wherever it was.
Jesus. That's
and then magically at 10 a.m. or 10:30 a.m., oh my God, a citizen searcher finds the RAV4.
Jesus.
Right? But that's their logic. That is the way they argued this without Sawinski even uttering a word in court.
Crazy. Absolutely crazy.
That's insane.
It's me.
Okay.
Number 38.
No.
Me.
Didn't you just read 37? No.
No. Jack read that one.
Okay.
That was me rambling on like a chicken. Number 38.
Yeah. Sorry.
We blame Jack because he got the order out of play.
That's right.
38. Additionally, although Avery argued Bobby had access to his blood, Avery claimed Bobby knew Avery was bleeding one day and Avery left blood in his trailer sink. Avery only offered conclusory statements and speculation that Bobby would be able to successfully collect and plant Avery's blood in a way that went undetected by crime scene professionals.
Okay.
And yet, if I could just make the comment, and yet Stephen and Brendan were able to expunge every drop of Teresa's blood that was not detected by forensic experts in the trailer and the garage. But only them two are able to do that. No other third party Denny can.
Yeah.
They should be millionaires behind bars.
Correct. Correct.
Number 39. Also, Avery also did not explain how Bobby had access to any of the other forensic evidence in this case. Post-conviction motion, Avery omitted any allegation that Bobby had access or the ability to collect and transfer his DNA, which was found on Hallbox's hood latch and her RAV4 key. Footnote 10. In his brief to this court, Avery states that he maintains law enforcement planted the touch DNA in this case. However, in his post-conviction motion, he alleged Bobby deposited Mr. Avery's DNA in the vehicle. He alleged Bobby deposited the blood, not the touch DNA. Correct?
Correct. I guess I don't remember.
He
I don't
did.
remember. Yeah. Yeah, I'm thinking to myself, I don't remember how the touch DNA was allegedly planted there.
Well, the only touch DNA is from the hood latch
Yeah, and the key.
and the key. Correct.
Yeah. Avery also omitted that police found a bullet inside Avery's garage that contained Halbach's DNA. It was fired from a rifle that was found inside Avery's trailer.
Okay. 40. It's my turn, right? I don't want to screw up again.
Yes.
40. The circuit court observed that pursuant to Wilson, Avery's theory of Bobby's involvement required Avery to provide evidence that Bobby had the realistic ability to carry out this complicated plan that he alleged was used to frame him. See Wilson. The court noted that Avery, quote, speculates on many points as to how Bobby could have carried out the plan to frame Avery, but the Wilson test requires more, end quote. The court determined Avery failed to offer any evidence that Bobby had the scientific knowledge to recognize the significance of each piece of forensic evidence supposedly planted by him, let alone establish that he had the skill to plant that evidence in a way that would stand up to scientific scrutiny by professional crime scene analysis. The court concluded that all the allegations implicating Bobby in the murder and framing of Avery are pure speculation and not supported by any evidence submitted by Avery. We agree with the circuit court. Did we miss 11? Oh, there's
11. It's right there. Yeah.
Yeah, I got it. In its analysis, the circuit court also observed that Avery's new defense theory that Bobby murdered Halbach and framed Avery for the crime failed to acknowledge Bobby's brother, Brendan Dassey. The court observed that Brendan confessed to and was convicted of participating in Halbach's murder, that Brendan, quote, specifically implicated Avery in this crime, end quote, and that Brendan's conviction was affirmed by the appellate courts. See State v. Dassey, Dassey v. Dittman, another citation.
Well, you see, without hijacking the podcast, I can speak for hours on that bullshit, and it is complete and utter bullshit. We've broken down Brendan Dassey, and I believe conclusively proved that he had no involvement and no idea of what has taken place. But from a legal standpoint, the court is correct.
It's done.
It's done like a dinner. So therefore, what Brendan confessed to is the truth. And Brendan implicated his uncle being involved in the murder of Teresa Halbach and the disposal of her RAV4. Because Brendan lost 4-3, it's now regarded as case over.
Yep.
Brendan was found guilty. Therefore, he confessed, even though he recanted. This is the facts. This is the court of law. Court of the law. Stephen is done.
That's right. Exactly right.
All right. My turn, number 41.
Yep.
Okay. 41. We conclude Bobby's mere presence on the Avery property and the Sawinski affidavit averring Bobby was pushing a RAV4 5 days after Halbach's murder does not establish any fact showing Bobby could have actually accomplished committing Halbach's murder and planting all of the evidence in this case. Nothing in the Sawinski affidavit establishes Bobby was in possession of the evidence that Avery asserts was used to frame him. In short, Avery's post-conviction motion fails to allege sufficient facts to support his theory that Bobby had opportunity, that he could have killed Hallbach and framed Avery for it. That's it. That's it right there.
Yep. That's the capture.
Yep.
42. We could again stop the analysis here. In his post-conviction motion, Avery has already failed to sufficiently plead 2 prongs of the Denny test. Once more, in the interest of completeness, we will continue the ridiculous analysis.
Well said. 43. The third prong of the quote-unquote legitimate test tendency test is a direct connection. Wilson. Direct connection is assessed by considering, quote, the proper evidence in conjunction with all other evidence to determine whether, under the totality of circumstances, the evidence suggests that a third-party perpetrator actually committed the crime, end quote, and takes the defendant's theory, quote unquote, beyond mere speculation. Quote, no bright lines can be drawn as to what constitutes a third party's direct connection to a crime. There's a footnote here, but it doesn't have a number. Shall I read it?
Yeah.
On appeal, Avery argues that the circuit court erred by referencing Brendan because Brendan's confession was not introduced into Mr. Avery's trial, and it is wholly improper for the circuit court to have factored the alleged confession into its analysis. We need not consider this argument because even without Brendan's confession, Avery's post-conviction motion still does not establish Bobby's opportunity under Denny. See State v. Blaylock. Cases are decided on the narrowest possible grounds. Interesting. Continuing. No bright lines can be drawn as to what this constitutes a third-party direct connection to a crime, but it must be more than a connection between the third party and the crime. It requires some direct connection between the third party and the perpetration of the crime.
44.
Jack, could you go back up there where you started reading 43? A direct connection. I was just thinking that the judge with all the evidence determine whether actually committed the crime. Takes the defendant's theory beyond mere speculation. Well, you know, there is no evidence of an actual crime scene on the Avery property.
No. There's not.
Where this crime occurred. So that was purely, they were speculating as well how this happened, where this happened.
They were able to sell it.
Yes. That's why Kratz wrote to Stephen in prison, saying, now is the time to tell your story so we know what happened. The state don't know. But see what they wrote there? That's real chilling. Because what they're saying, their argument is this. We don't care if Sawinski saw Bobby Dassey and another male pushing with their hands Teresa's RAV4. If you can't link Bobby to the murder of Teresa Hallbach, we don't want to know. So basically, you see what it's saying? Yeah. Actually committed the crime. So their argument is, well, maybe Bobby was helping his uncle hide the RAV to crush it. Maybe Stephen asked his nephew, hey, I've got the RAV4 over here, bring it on the property and I'll crush it. So therefore, if you don't have a videotape of Bobby or a third party Denny committing the crime, they don't want to know about it. You're speculating.
Right.
Yep.
They're basically completely ignoring Sawinski's affidavit and the phone call
Correct.
and his affidavit of his fiance.
Correct. 100%. They're eliminating it, totally getting
Yeah.
rid of it.
I agree.
44, is that me? Yeah, that's me.
Yeah.
That's you.
In his post-conviction motion, Avery argued, quote, "The Sawinski evidence demonstrates that Bobby could have committed the murder because he is in possession of Miss Hallbach's vehicle, where the murder likely occurred as evidenced by Miss Hallbach's blood in the vehicle. The vehicle is a key piece of evidence in the crime." End quote. Oh, is that
45. The circuit court disagreed. It stated, assuming for the purposes of this motion that everything averred to in the Sawinski affidavit is true, the defendant is incorrect in his assertion that the facts in the affidavit provide a direct link between Bobby and the Hallbach murder. The defense that ipso facto, if Bobby was in possession of the victim's car that night, he must also have been the individual who committed the murder. No evidence submitted by the defendant supports this conclusion. Even if Bobby was found in the possession of the victim's automobile on the night of November 5, 2005, the morning of November 5, there is only speculation and no evidence to prove that Bobby was in possession or that he had exclusive control over the vehicle prior to that night.
I'm dumbfounded.
So understand
Only
the significance.
speculation that he was in possession of the car. It's not just speculation. It's Lewinsky's statement.
Sworn statement. Sworn statement.
Right. You,
Whose
Jack.
turn is it? Is it me? Sorry.
You. Yeah.
I'm getting texted. I'm sorry. All right, 46. We agree with the circuit court. Sawinski's avertments that he purportedly saw Bobby and someone else pushing a RAV4 on November 5 days after the Hallbach murder, do not provide a link between Bobby and the perpetration of the murder, nor any factual link between Bobby and any of the forensic evidence. At most, Sawinski's affidavit establishes a possible connection between the third party and the crime. C. Wilson.
Are you here, Doc?
No, that's still part of Jack 61.
Oh, I'm sorry, Wilson. I'm sorry. My bad. However, that is not enough. Avery's post-conviction motion does not sufficiently allege facts that demonstrate Bobby had a direct connection to murdering Hallbach and framing Avery for it.
If I could just make a comment. Where have you ever seen an example like this?
Never.
Where if Sawinski said, I saw Bobby Dassey pushing the RAV4, I don't think it could be any other potential RAV4. It's likely, very likely, fits the description of Teresa Hallbach's RAV4. Where have you ever seen the court arguing, we don't care if Bobby was pushing the RAV4 because you can't prove that Bobby had killed Teresa Hallbach? It's not an issue and we're not going to consider it any further. Because if the court was thinking, this honestly doesn't look good, what the hell is Stephen's nephew doing with the victim's RAV4? Let's call up Sawinski and let's talk to him. Let's put him on the stand. The court has found no reason to question Sawinski. You get it? So they're saying, I don't care if you can't prove you. So in other words, they're not saying it's a direct connection. They're not saying it's a direct connection. So having your hands on the victim's vehicle, pushing it on the salvage yard is not a direct connection.
That's right.
Maybe they were doing a good Samaritan deed. They saw a car on the road and thought, oh, why don't we just push it at 2:00 in the morning on the salvage yard? And we won't tell anybody about it.
That's
And
right.
we'll cover it with branches and trees. Or we'll take off the license plate and we'll do such and such. I've never seen any argument like this. And yet, here it is.
Just when you thought you couldn't be surprised further, here we go.
Here we go. Is it my turn, number 47?
I think so.
Okay. 47. Because Avery's post-conviction motion did not allege sufficient facts to satisfy the Denny requirements for third-party perpetrator evidence, the Sawinski evidence is not material and therefore does not satisfy the newly discovered evidence test. See Volbrecht. We therefore do not determine whether the, quote, evidence is not merely cumulative, quote, the fourth factor, or whether a reasonable probability exists that a different result will be reached at a new trial. See Edmonds. Avery's motion is insufficiently pled.
Number 48. We pause here to discuss the affidavit. As stated previously, after briefing on Avery's post-conviction motion concluded, Avery filed an affidavit from Baresh. Avery's post-conviction counsel moved to amend a single paragraph in the post-conviction motion so that the amended paragraph would read, the Sawinski evidence provided by Mr. Sawinski to Mr. Avery's current post-conviction counsel is newly discovered evidence, which provides the missing direct connection and Ms. Halbach's murder, making him a Denny suspect. Mr. Thomas Baresh corroborates the previously filed affidavit of Thomas Sawinski that Bobby Dassey was driving the RAV4 vehicle of Teresa Halbach on Friday night, November 4th, or early Saturday morning after her disappearance on October 31, 2005.
49. The circuit court analyzed Baresh's affidavit and determined nothing in Baresh's affidavit links Bobby to Halbach's murder.
Point 50. We conclude Avery's motion is insufficiently pled in regard to the Baresh affidavit. Avery referenced Baresh one time in the entirety of his post-conviction motion. He did not offer any analysis or assertions within his motion as to how Baresh's affidavit met the four criteria of newly discovered evidence or established a reasonable probability that a different result would be reached at trial. See Edmonds. Avery did not sufficiently plead the Baresh affidavit as newly discovered evidence. In any event, we agree with the circuit court that Baresh's affidavit does not link Bobby to Halbach's murder.
51.
Driving her car.
Yep.
51.
Exactly.
Driving your car.
Yeah.
I think I'm after Doc.
Yes.
Oh, you are. My bad.
Finally, Avery argues the circuit court made a variety of factual errors in its written decision that are unsupported. We have already addressed some of these purported errors. Other examples include that the court referred to Bobby as Brian at one point in its decision, stated Brendan was forensically linked to the crime, stated Halbach's bones were found in Avery's burn barrel, her electronics were found there, her bones were found in multiple locations, including Avery's burn pit, and stated bone fragments from almost every bone in the human body were found in the burn pit. This statement, however, was proven at trial by the forensic anthropologist, who found at least one fragment from nearly every bone in the human body within the burn pit. We have reviewed the purported errors and conclude they have no bearing on the circuit court's denial of Avery's post-conviction motion. By the court, order affirmed. The opinion will not be published.
Of course not.
See, Wisconsin statute, rule 809.
Well, shake my head. But, you know, I'm, you know, I would be lying if I said I wasn't surprised. Let me put it that way. I'm not surprised at all. You know, being involved in this as long as I have, as long as you guys have, we've learned, you know, a harsh but true lesson that they're not going to give an inch, not 1 inch.
Nope.
And
Finality.
finality. That's right. It's crazy. It's just absolutely crazy to me. You know, you think about, again, we don't have to name Bobby or some other unknown person. It could be anybody. And they have possession of a murdered victim's vehicle 5 days after this alleged crime. And they're not linked. You got somebody swearing they saw X, Y, and Z at, you know, 2:00 in the morning on a certain date, pushing that vehicle, and there's no connection. They're like, well, you know, you can't prove, didn't see any electronics, didn't see any keys, so big deal. I've never heard anything
You know
like
that
this.
it was her car. That's
Well, you're right. You know, I think about some of the more current cases, the Karen Reeds, and you know some of the other ones, and we've seen these. You know, that damn case out of Georgia, that Raffer case, that RICO case, and some of the oh my God, you
yeah.
know what I'm talking about.
Yeah.
Some of the most insane decisions by the judges in that case. I've never seen anything like it. Now, it kind of goes along with some of the crazy shit that I'm seeing out of the Court of Appeals. Again, anyway, I don't want to ramble on too much. I'm not
Travis
surprised.
says- oh, sorry.
No, go ahead. No, go ahead.
He just said the denial of the evidentiary hearing on the bones. The logic was more twisted than this. And that's where I got my name, inexplicable.
Yep.
That's
right.
where that came from. It was
Yep.
just inexplicable. They gave the bones back to the hall box.
Yeah, they did it, but we don't really know why. But it's okay. Got your back, guys.
Yep.
Doc?
I don't even know where to start, Jack 61. But I'm not surprised. And it's great that we've read this and went over it. And the good thing is that we've done what? 200 podcasts on everything that was discussed here. We've covered a huge amount of stuff. It doesn't surprise me. These are professional lawyers, attorneys. Their aim is to shut the case down. They do not want any further discussion. They want to close this case, close the arguments. They don't want to present anymore. They don't want to open up Pandora's box. And, you know, look, as harsh as I want to say this, and it breaks my heart, they're technically correct. What they argued here, they are technically correct. We know because we sit on the outside and we look at all the forensic evidence and what has been found, and we can argue and take apart the state's case very, very easily. But from their viewpoint and from their argument and from their side, they're technically correct.
Yeah.
When I read the argument about, and a big argument was, hey, listen, you cannot find any forensic evidence linking Bobby Dassey to this crime. In the same freaking report, they admitted, hey, we can't find any forensic evidence linking Brendan Dassey to this crime. But it's remarkable that because Brendan's in prison and was convicted by 12 of his peers, that's cool. So the kid's in prison and he's going to stay there till he's an old man. Why? Because he lost 4-3 when the judges were arguing it. It wasn't a 7-0. was a 4-3. So by the letter of the law, what they wrote down in this report is correct. But factually, ethically, is it correct? It's the biggest lot of crap I've ever seen in my life. But legally, it went through. No problems, no arguments.
Yeah, I mean, we've been fortunate. You know, we've had some really good lawyers. Travis has been around for forever, and he's been kind enough to lend his knowledge and of how courts operate. Because you know, when I got involved, I mean, I knew that there were issues within the various courts, of course, but the depths of what I thought how things went and the actual truth of the process was completely obliterated. I really didn't understand that they have a process that they follow, but they get into, you know, a case like this, and it was complicated. It was a complicated case, but the double standards that they apply are insane. Number one,
Yes.
you know, they completely ignored the phone call. Did you notice they didn't even mention the phone call at all? Or that the fact that it was buried for, 16 and a half years. Buried. We had no idea that the phone call even existed until early
Yeah, not even
2022.
mentioned.
No, not even mentioned.
in this.
No, not at all.
Uh.
And some of the other stuff that we read early on that I really I can't wrap my head around, especially the Beely CD. It was allegedly work product or whatever. For Fassbender holds on to it for a year and whatever, and then it suddenly becomes evidence because it gets entered into the ledgers and filed away with Uyghur for safekeeping, and so now it's evidence. If it was, it's just wrong. Okay, that's a, and if this was the other way, and the defense had something that they had kind of squirreled away or whatever, putting that shoe on the other foot, and then it suddenly become evidence after the fact. Now, what kind of hell do you think the state would have raised about it? Right?
A lot. Yeah, a lot.
Well, it would have exploded. They would have went after Beauty and String for their bar card.
Correct. But at the end of the day, Jack 61, this case has a lot of eyes on it. Right?
Oh,
it's
yeah.
It's not like an ordinary, and I hate to use that word, ordinary murder case.
No.
It's not, because of the millions of people that are interested in this case and have spent a lot of time deep diving and looking at all aspects. The aim of the state is to put borders on what can be said and what can't be talked about. So they're putting on blinkers and a restriction. They know that if they let Kathleen Zellner have access to the RAV4, the blinker light, and the number plates, and do further forensic testing, all hell can potentially break loose. That's letting out the genie out of the bottle. They don't want to do that. So their arguments are very, very clever. So if, and I think Travis said it in the chat, if you don't have a direct video evidence showing a third-party Denny suspect being involved in this murder and have a direct connection, then it's pure speculation. And so that's their argument, that now Stephen has to now provide a motive, and he has to provide a direct connection to Bobby, to Teresa. And yet, isn't it interesting that the only two people on the Avery Salvage Yard, as far as we are aware, that saw Teresa at 2:35 p.m. on the Avery Salvage Yard is Stephen and Bobby.
That's right. That's right.
Just then.
Not even seen driving in or driving out.
No.
By Earl and Chuck.
That we know.
That we know of.
We know
they're
of.
admitting. Yeah, that they're admitting to. That's right.
Correct.
And I'm guessing that could happen. If they were up in one of the bays working on whatever, they could easily miss that. But I don't know.
Correct. Correct. And remember, we've had fantastic discussions. I remember in Jeff Jones, when we were doing all the podcasts with Jeff Jones, remember having all these arguments, great discussion, saying the diversion in the story occurred between Stephen and Bobby, right?
Yes.
Stephen said, I saw her leave. Bobby goes, I saw Teresa walk towards Stephen's trailer. And then it's incredible that when you deep dive and you look at Bobby's narrative and recollections, they widely differ. He's
Yes.
changing his story, his narrative. I had a shower before, I had a shower after.
Yeah.
I didn't do anything. I immediately left. Oh, no, I got ready for hunting. And it's all those critical moments, revolving circle, that are so crucial to the state's narrative. Because you know what Kratz did? Kratz tried to expand out the time. Oh, so Bobby saw Teresa take pictures and then he went for a shower. And when he came back, he saw Teresa.
Wasn't nowhere
She
around.
was gone. Where's
Yep.
Teresa? I saw the RAV4 there, but I didn't see Teresa. Oh my God. 10 minutes has gone by, 15 minutes has gone by. But the reality is it could have been 30 seconds that have gone by.
Right.
But by changing the narrative, you see how the state can manipulate any story that they want.
That's
So
right.
Bobby Dassey is the bookmark. You understand?
Sure.
He's the bookmark because he saw Teresa arrive, take photos, and then start walking towards Stephen's trailer. He left for bow hunting. He glimpsed the RAV4. He had no idea whether Teresa was there, writing down something on a note, and it just was timing wise. But he's the bookmark because what did Bobby say? When I came back from hunting, did you notice her RAV4 there? No.
No.
Whereas Brendan gave 3 different versions. Yeah, I saw the RAV4 outside. Oh, no, I saw it in the garage with the snow sticking out. Or what RAV4? So
Or it was over by the tree.
it was over by the tree. So
Or
Yeah.
she was driving out as he was walking in and he had to
Yeah.
go around her.
That
that's
was another
correct.
version.
Step aside. He had to step
Yeah.
aside with his brother.
Well, and
Correct.
another
Mhm.
story and another statement, Bobby told Loy and I can't remember the investigator's
Yes.
name, that he saw Stephen walking toward his garage, not Teresa.
That's correct.
So
that is
yeah,
correct.
so
Earlier
now
on.
we've got another wrinkle in the whole thing.
Correct.
I'm just going to put this out there. I'll put the link. I didn't put it in YouTube yet, but I did put it link to the Streamyard in Discord if anybody wants to jump in. And I'm glad to put it in the live chat if anybody wants to jump in and have their opinion. I'm glad to do that if anybody's interested. If not, then that's okay too. So if anybody wants to jump in, let me know. I'll throw it in the YouTube live chat. You've had a pretty good crowd tonight listening in and commenting, and that's fantastic. So, Susan, thoughts? While we're waiting for a second, we got a few questions too, by the way.
My brain is not. It's just
You're
so. It's so frustrating, you know. It's just so frustrating.
It is.
It's the same thing every single time.
Well, yeah, if for them to agree with Sakevich on basically anything is mind blowing to me. She set the bar. I mean, I don't know other cases in Wisconsin if the bar is set as high as it is in Stephen's case. I imagine maybe for some cases it probably is. I mean, I always refer back to the lawsuit and the implications that it had for not only Manitowoc but even state officials, the crime lab. To me, the lawsuit is at the heart. That is the go-between between the 85 case and the Havok case. I can't see it any other way. I can't. I've tried to discount one thing or another, but if I do that, I have to compromise, and I'm not willing to do that. I can't do that if I'm trying to be truthful.
The two are connected, in my
Yes.
opinion.
Yes.
And it's interesting because and Susan pointed out to me on Defense Diaries, they did something very similar to this. They read it out, and remember, they're defense attorneys. They've got legal knowledge, and I listened to their arguments. But something that I think Bob said that chilled me to my bone. He's of the belief that this was done by a family member.
Well,
Somebody on the property, yeah.
yeah.
But he's also not aware that there were a lot of customers on that property.
True. And some
of which
unsavory characters.
Unsavory. Yeah.
Yeah.
Correct.
Sure.
Is another possibility.
Correct.
Right.
And that's why I thought instead of taking into account people's recollections, bypass all that. Get the RAF, get the forensic evidence and test it. See what is there. Can you explain it? They don't want Zellner anywhere near the forensic evidence because it's going to open up a can of worms, right? And, it still echoes in my head what they said on a cam, convicting a murderer. Well, let's think about this, right? Someone had to know the yard. Someone had to know the locations. Someone had to know that Stephen bled.
Yeah.
Fuck. It points to one person and one person only. And I'm even too scared to say the name. But it all works out. It all works out.
Well, I know who you're talking about.
Yep.
And that person. Yeah, I mean, that person had some real anger issues.
Yep.
For decades. Yep. We know that. And again,
when you flip it, sorry, Jaxie, when you flip it, it's to do with money. It's still to do with money.
Sure. Right?
And the power of money and the ability to change things. And you're thinking, oh my God, who on the salvage yard has a potential criminal record that could involve murdering somebody? Then when you read it, you go, oh yeah. And there's no, I'm not going to say names, but Kim Skolinski, I think, was on the right money. He had his suspicion. He had his suspicion.
He did.
Yep. And Cherie Lynn Pontillo reminded me the other day about, what about these missing women back in the 80s, 90s? Yes. Right? And I'm there, oh my God, that's exactly what Skolinski told so-and-so about. And I'm thinking, so why would Skolinski be mentioning this woman? I think she was from Wisconsin, murdered, disappeared, just disappeared out. She was driving her car to her boyfriend's house and disappeared. Deputies. And he said this to one of Stephen's brothers. And I'm there, oh yeah? Why? Why would he say that?
Yeah. Case File Reviewer did a pretty extensive list. I don't know if it's still on Reddit or not, but it was shocking. And I'm not talking about all over Wisconsin. I'm talking about in that region right there, that 4 or 5 county region surrounding Manitowoc.
Yeah.
And he didn't even list everything that he had, but it was still an extensive list of these disappearances of these young brunette, more petite. Go ahead.
You know what's scary? When you compare the photographs of Lauren Dupree?
Yeah, Lauren. Yeah.
And Teresa Horbach, their yes pictures.
Oh yeah.
They almost look identical.
They're very, very similar.
Very similar. God. It is so frightening. I think, again, I don't want to start speculation, rumor, and all that sort of crap. I don't even think we've scratched the surface of what happened in Wisconsin.
Oh,
I don't think we scratched the surface. This is deep. No. Fucking deep. Yep.
It was interesting when I was looking for the appeal to be posted on the COA site. I actually read the Court of Appeals opinion on the 96 motion for Stephen for a new trial with the DNA evidence, 96 or 97.
It was 96.
Which was denied.
Correct.
It's very interesting to read.
Judge Hazelwood.
I'm
Yeah.
not ridiculous.
Judge Hazelwood. Correct. So if there's any type of doubt,
I mean, they had DNA, right?
correct?
From under
Yes,
her
they did.
fingernails.
Yes, they did. They did. But back
But
then,
it wasn't
the DNA
enough.
no. The DNA profiles were very primitive. They looked at 3 alleles. I went into this deep. They only looked at 3 loci, and the alleles were different between Stephen and Penny. There were unknown alleles underneath Penny's fingernails, and the judge goes, "I can either side with you, or I could side with the state. Fuck it, I'm siding with the state. Why? Because Penny could have touched somebody and got their DNA underneath, like a rescuer,
Sure.
right? Rather than the attacker." So Judge Hazelwood said, "You're going back to prison, mate."
Yep.
And he did. So Stephen went back to prison. Correct.
That's right. Okay. I think this question, we've got a few questions, and I think I highlighted a comment or two that I caught. If I missed your question, please forgive me. I did try to double check, but anyway, this is from Pennywise, and I think Travis answered this, but you guys can, if you want to comment or whatever. Susan, you want to read that out from Pennywise?
Sure. Pennywise. Can Casey ask for testing while seeking the Wisconsin Supreme Court review? She said she would never darken the door of the federal level, so why bother with the Wisconsin Supreme Court over eyewitnesses? Well, they're not federal, they're state. And it's just a matter of record, I think, getting it on the record that she appealed that decision.
I don't think she can ask for testing until, I don't know procedurally if that's allowed or not.
Well,
Travis probably answered that, and I didn't catch it. I know there was a conversation, and I didn't catch it all.
Right.
But yeah, you pointed it out. Well, the Wisconsin Supreme Court is still the state level, and even going to the Supreme Court, they may decide to not even hear the case at all, like they did before. They could just say, "We're not interested."
Yeah. More than likely to happen. But,
Chances.
It'll probably cost another 9 months, a year, maybe longer, who knows?
Yep. Stretch it out again.
Yeah.
Okay. Have a comment from Travis. Doc, you want to read this out?
Yeah. Jack, I know you remember when I went over this here on a couple of panels, and I was very optimistic on this one because the trial court would make it impossible to get any evidentiary hearing.
Yeah. Yeah, he had said this, I think, at a point where I was complaining about some of the things that the Court of Appeals had included. And I do remember it, Travis. So
Travis also
right.
says she cannot ask for testing while appeals are pending. Can't ask for testing that she has already asked for. Although the circuit court dismissed it without prejudice. So her last bid to test the RAV.
She can refile.
Yeah, but she would have to wait until after the Supreme Court.
That's right. Correct. Okay. This next one is a comment. Susan, you want to read this one?
Sure. I think Brad Schimmel is running for Supreme Court in Wisconsin. Wonderful. I will not be voting for him, and he's a Republican. That's scary for me. I don't vote him.
Yeah, he is running. No
Sometimes
matter
it
what
goes
your politics are.
beyond party lines. Yeah.
Well, considering the actions that he pulled when Brendan was in his appeals, he had not 9,000 heart attacks. Actually, like
It's
Brendan
all
was,
him.
worse
him.
than Hannibal Lecter. I have nothing for that guy. Nothing.
Yeah.
Thoughts, Doc?
Yeah, I 100% agree. It's the same people who want to get into high positions to shut everything down. Because remember, this looks very, very bad for Wisconsin. The eyes of the world are looking at this case. Now, people might argue Stephen's guilty, Brendan's guilty, but hey, give him a fair trial, right? This was not a fair trial. And we listed all the things that went wrong that Kratz did, especially Kratz, and also how aggressive Brad Schimmel was towards Brendan. He wanted to make sure that Brendan didn't take 1 foot out of prison, and he was successful in that. So, yes, this is a very highly emotive case. They're going to shut it down. They want to shut it down. They don't want to open any door. Now, the state saw what happened when Kathleen Zellner examined item FL, right? And how that was completely debunked and destroyed. Looking at the wrap, looking at the plates, looking at the broken blinker light, you'd imagine what her DNA experts and trace forensic experts are going to do with the RAV. Oh my God, it's going to give a story that's either going to be very damning for Stephen or Brendan or totally exculpatory, saying, guys, what the hell are you doing here? This doesn't make any sense.
That's right.
I don't want to open that door.
No.
So two people, you may argue with Stephen, because with Stephen, the forensic evidence points to him, but the forensic evidence makes no sense. But Brendan, surely, if you're thinking logically and not emotionally, and just look at the forensic evidence, you go, the kid had no idea, right? So argue as much as you want with Stephen, no hassles, but with Brendan, what the hell is that kid doing in prison? It makes no
nothing. They have nothing.
No sense, right? And you saw it. We spent, years, and with the Reading with the Crew series, with Jack 61, with his open mics, the phone calls, the documents, we've gone through it bit by bit, their own words. Now, their CSI, remember what they said in the document about, wow, they fooled the CSI. So how did two guys with low IQs fool the full CSI team of the Wisconsin state? They found no blood.
They should both be millionaires behind bars.
Yep, or start up a forensic cleaning company. All jokes aside, how do they do it? And the answer is, it's amazing because, Jack 61, because Jack 61 and myself, we go on X, we read the arguments, we read the counter arguments. A lot of people are not prepared to say the reason why Brutus never found any cremains or never went to the burn pit is because the cremains weren't there. There's excuse after excuse after excuse.
Amazingly,
it's so funny reading it. It's beyond a joke.
I'm going to show you the photo that I had picked out for our ending photo. Been sitting here the entire time. I've had it open.
Yep. Oh yeah.
The arguments are that Brutus was, or not Brutus. I'm sorry, Bear was this mean, vicious dog. Well, again, I have no doubt that when people pulled up in the drive that he barked. I have no doubt of that. He's a dog. That's where he lives. You're on his space.
That's his space. You're correct. But also Jack 61, dogs are territorial, but also dogs are very routine in their nature. Yeah. You think about what happened. All of a sudden, his owner is no longer there. They're all at Crivets. The whole family is at Crivets. His daily routine is changed. He's now got people feeding him, law enforcement officers like Jost feeding him. Bear's probably going, huh? You're not my normal owner. So it's a change in routine for the dog, for the animal. And animals are very routine based. If the dog gets fed at a certain time, they're looking for that. And everything is being disrupted. All of a sudden, you've got all these strangers coming around where he is, going inside Stephen's house, in the garage that he's never seen before. And people go, oh my God, the dog barked. big
and all
fucking deal. If you're
all
a
factory
dog and you,
from an all factory part of it.
exactly, the dog's smelling all these different people going,
Yeah,
are they
who the
come
hell
here
are
to
you?
rob? Are they come here to rob my owner's house or the garage? What the hell are they doing here? So people are coming with all these weird explanations of Bear's behavior. And quite clearly on November the 6th, was Bear aggressive to those two law enforcement officers who were in striking range of the dog? No,
No.
couldn't give a stuff.
Well, and the photo after this where Reese is standing basically right beside the burn
Right
pit.
at the burn pit with a dog with his back. It is hilarious to read. Hilarious. But like I said, the issue is this: when people take a side, they must never falter. You understand? If you
Sure.
believe Stephen and Brendan are guilty, you can never falter on anything. Whereas I'll look at it, you'll look at it, Susan will look at it and go, okay, can we explain it? Is there something weird going on that we can't explain? Dogs are dogs. They're going to react to car alarms. Hell, my dogs bark like hell when a car alarm went off. But when Bear does it, oh, that's
He's
aggressive.
mean and he's vicious. He's vicious and aggressive.
He's and yet, you know, the real funny thing is, right? They took Bear off on November the 8th from the burn pit because you can see the chain there. Who went up to Bear, a vicious, aggressive German Shepherd, and took him off the chain and moved him to, I think, where Barb was? Who moved him? So suddenly now Bear is no longer aggressive? Come on.
Correct. Well,
It's
and
ridiculous.
took the vet 7 minutes to
7
sign
minutes
in
to
and
get
sign
him
out.
off. Yep. 7 minutes
Yeah.
to get him off.
We got one more comment or question. This is non-related to Stephen. I guess it's kind of maybe a dotted line, but from Kansas Boxley, any news on Remaker? And I haven't heard anything.
Me neither.
Yeah, I
I haven't
haven't
heard
either. I haven't looked at it, but
No, I
Not
haven't
sure.
looked at his case compilation at all. But maybe that's something we can look into here in the next day or two.
Yeah.
Oh, okay. I'm not sure if we have any other comments. It doesn't look like we got. I see Scoob and Benny Bruce fan. We've been on several comments and conversations going on.
It's been really good. Really
It has.
conversation.
Yeah. We had a pretty good crowd listening in and commenting. Again, I want to thank Travis for his legal knowledge and contributing to the case, helping us understand the process. So I guess we'll see what the Wisconsin Supreme Court does. I suspect they won't hear the case, but the GAR has changed. It politically speaking, it's democratically controlled now. I don't know if that'll have any effect or not. It may not matter at all. But there's
Yeah,
no
it-
doubt these cases are still criminally and politically a grenade. They are. And anybody
No.
that thinks differently, they're not reading, they're not looking at the implications.
Yep.
So
Someone in legal authority and power has to swim against the tide. They're not going to do
Yeah.
it.
no.
They have to swim against their colleagues and their advice. And I could bet you I know who's right behind all of this. Tom Fallon.
Well, that wouldn't surprise me at all. He's super
Oh, yeah.
intelligent. He's a
Oh,
super
absolutely.
intelligent guy.
Yep. Absolutely.
So, all right. Well, unless there's anything
Brendan's
else, I
stuck till
guess
2048.
2048. Correct.
Yeah. Oh, I see under your scarf.
Long
Yeah.
way.
Yeah.
Yep.
He's still got.
2048.
So what's that? 23 years from now.
He'll be in his late 50s when he comes out.
Yep, he will. He'll spend the bulk of his natural life in prison unless he lives to be, 125.
And thank
Such a
input. I appreciate it. We appreciate your expertise.
Yep, absolutely. Well, yeah, and and Doc's work and research has been nothing short of excellent to me. I mean, a lot of it I knew,
Yeah.
all of it I've read, but I didn't put it together. You know what I'm
Yeah, it's
saying?
putting it
As
together.
we get more intelligent, obviously, as the case continues to progress. We see things later differently than we saw it when we first read it, you know, a few years ago, because now we have more information to add to it.
Yes.
Yeah. So fantastic job on the reading with the crew. You know, we've gotten into this debt, you know, and we were, you know, they released more evidence in October of 2024, which is shit we'd never seen before.
No.
The Sturtevant drawing.
Yep.
I didn't take any photographs or order any taken, but I got you this, you know, 1850s drawing that they did back then because they couldn't find they didn't have photography available. And he could have had 5 photographers there within 30 minutes or less, probably.
Yeah, and the crime lab took what, 3 hours to get there?
Well, they
Or was it
waited an hour they waited an hour and a half to call him. They waited an hour and a half to call him, and then it took them, I don't know, I guess an hour. Yeah, it took them some time to get there. I don't remember exactly, but
Yep.
Yeah. Alrighty. If no one has anything else, I'm glad to wrap this up. Appreciate everyone, Doc, Susan. Always much appreciated. You know, reading this document. Fantastic as always. Certainly want to thank everyone that's in the live chat that's joined us. We had a pretty good crowd tonight. You know, keep on keeping on those that are, you know, requesting documents and so forth. You know, I'm so I can't even say pissed off is the right word. I'm scathing mad that they've stonewalled me. They're continuing to stonewall me. I've got requests in that are years old at this point. I've got simple requests in that are years old that should have been done long ago. That it's like they just play this game, and the really irritating part that there's no consequences. There's no for these records custodians that are in charge of these records that just decide to, you know, not release them, and they should. There's no legal reason for them not to release them that I'm aware of, and I've looked. Trust me, it's really frustrating. And I know for anyone out there that's listening that is trying to get records, that even if you're not going to share them publicly, it's got to be a real irritation for you as well. Anyway, any final thoughts before I jump out? We good?
Good, Jack.
Everybody
have a great night, day, wherever you are.
I was going to say that I'm still putting together the next reading with the crew. Hopefully, I'll be able to get it done in time. I don't want to rush it. There's a lot to put together. We're continuing with Brendan's narrative, but we're getting some really good feedback about the last one we did regarding the bullet. That was a really good one. I really enjoyed that podcast. It was some great comments and great feedback. Thank you so much. So we'll try our best.
Alrighty, sounds good. We will definitely continue on with, unless something happens between now and Sunday, we'll continue on with the open mic, reading the more of the new documents from the DCI report, and yeah. Alrighty, I'm going to end this by saying thanks everyone. This has been a Foul Play production.